फ्रेंड्स, हाउ आर यू? कैसा है तुम्ही? कैसे हैं आप सब लोग? आई थिंक दैट यू ऑल आर गुड. आई एम ऑल्सो गुड एंड टुडे वी विल डिस्कस एन important topic about bail. Bail is basically consent with your liberty. And whenever we submit our plea for bail, we might be in anxiety because everyone wants a bail. But it is not easier to get a bail more specifically in cases consent with corruption, cheating, forgery, and misappropriation. And basically, we have to ascertain that certain guidelines are followed by the concerned police. And apart from that, our pleading should be effective so that we could point out the non compliance and could effectively put up our side dominantly. I will discuss the recent judgment of Honorable MP High Court, which is dated 6th of March 2026, which is in favor of accused. In that case, there was a FIR. And finally, accused was prosecuted as per section 13, subclause 1, subclause D of PC Act. And apart from that, there was section 7 of PC Act, along with section 409, section 120B, section 467 of IPC. The prime allegation was that the accused was indulged in the activity of money diversion. So whenever the allegations are imposed on the accused and ultimately he is arrested, there is a need to read the FIR. First of all, we have to ascertain the nature of allegations. We have to ascertain whether the allegations are specific or non-specific. If allegations are general, non-specific, and even the FIR is delayed, the same could be the good grounds for bail. So do not be in anxiety while moving for the bail. Just observe the FIR, what FIR says. For example, you are a private person and internally indulged in a corruption case. More specifically, as per section 7, section 13(1)(d) of PC Act, do you think that the said section would be applicable on you? The answer is in negative. If you are a private person, you could not be prosecuted as per section 7, 13(1)(d) of PC Act. So, if you are going to apply for the bail, you may have a direct hit. And apart from that, if the allegation pertains to cheating, as we know that concerning cheating, the element of deception must be on record. If there is no deception, in that scenario, we could have the benefit. You got the point now? And apart from that, concerning forgery, specific averments with specific evidence are required to be on record. If there is nothing on record, everything is based on surmises and conjecture, we could have the benefit. And again, I am going to specify you regarding criminal conspiracy, the facts must be on record that two or more than two accused are hatching a plan to commit a crime. If there is no specification, even in light of section 8 of BSA, we could have the benefit. So basically, we have to ascertain the facts from the FIR. We have to find out our role. And apart from that, we have to find out whether our role is specific, non-specific, whether against us the allegations are general and specific. And apart from that, we are supposed to give the proper answer to the concerned FIR so that we could inter alia put up the plausible scenario on record. We are not supposed to prove our defense beyond reasonable doubt. And apart from that, in case of forgery, cheating, misappropriation, criminal misconduct, there is no presumption against us. The prosecution has to prove the case. But simply we are supposed to give a plausible explanation so that we could create a suspect in the case of prosecution. And apart from that, if the accused is in jail since a long time and there is no compliance of section 35 subclause 3 of BNSS, the evidence is not direct, the evidence is not specific, it is general. And apart from that, the allegation regarding the amount diversion, if there, and inter alia, the amount has been refunded, and accused inter alia shows his willingness to deposit the amount as per direction of the Honorable Court. The amount means the amount which is alleged to be diverted or alleged to be involved or suspected in the crime. In that scenario, we could chalk out a very good case for bail. And apart from that, if accused is not having the criminal record and he is ready and willing to cooperate in the investigation or in the trial proceeding, then the case of bail would be on the dominant side. So in that way, we have to proceed and have to submit our argument. And apart from that, we could rely on the recent judgment of Honorable MP High Court, which is dated 6th of March 2026, which is quite important and quite landmark in said scenario. So whenever we are going to submit our argument, just specify your argument, make it pinpoint, make it properly oriented, make it properly structured, so that we could have a very good case for bail on record. So I think that I have enlightened you about the subject in the easier manner. For any query, just write in the comment box. See you in the next lecture.